question I get asked all the time. What rights do I have if my employer is requiring me to physically come back to work and work with respect to safety issues? And what rights do I have if I do that and they don't provide me with a lot of safety and then something happens? So we get asked this question all the time. And the answer is that you have rights that you can act on. And first is if your employer is requiring you to go back to work, he needs to comply with the New York State and or New York City regulations with respect to doing that. So you first have to see what are the city regulations, what are the state regulations with respect to you being in your office workplace, and you have to be in compliance with that. So that has changed frequently as we've progressed with COVID. But for the most part, offices the governor and the mayor have not precluded any businesses from requiring their staff to come back, albeit with restrictions on numbers and on safety precautions. So if that first hurdle is clear that they're allowed to ask you to come back to work, then the second one would be that they put in place reasonable safety measures to allow for you to be there properly. And that being, you should be permitted to wear a mask. You should be provided masks if you want one. There should be the ability to socially distance and comply with all of the other city and state regulations with respect to COVID that exist outside of the office and in restaurants, bars, things like that. So in your office, you have the same right to expect that to happen. If that's not happening, so you have a supervisor, a boss saying, I could care less what the regulations are. If you don't show up tomorrow, you're fired. And when you show up, you're in a room with 50 people, no one's wearing a mask, there's no ventilation, no precautions. And if something happens, you're going to have a case. I mean, it's as simple as that. Is it going to be an easy case or a clean case? Not necessarily, because you first have to have damages. So let's suppose that would be you contracted COVID. Hopefully that didn't happen. And then how significant are your damages? Because if you contracted COVID and you have mild or no symptoms, not really much of damages. If on the other hand, you have the more serious case, then your damages may be big enough to be actionable. And then you have to go about like you would in any other case. Prove that there was negligence. Negligence just being unreasonable actions on behalf of somebody. So in this hypothetical case we're talking about, that would be a boss that forced you to come back to work but didn't have any reasonable precautions in place. It's pretty rare, by the way, in New York that I would see that. Most of the employers are taking precautions, but let's assume one doesn't. So now you have a negligence situation, and then you'd have to prove causation. That's a little more complex. In other words, that I contracted COVID and got it at my workplace because of these situations. So that sort of goes to this contact tracing issue that we all have, and that's a little bit more complex. I will say that the first thing that happened, and I spoke about this probably in the first few weeks of COVID, is the first people that were having COVID litigation, let's say, would be in the workers' compensation context. So people coming back to work and getting sick and then saying, not suing their employer, but rather saying, well, I need benefits. I'm out sick for 2 weeks or 3 weeks or whatever it is. I want benefits. And what the Workers' Compensation Board did, which I thought was very reasonable and thought would happen, is they just basically came up with a presumption that you did contract it at your workplace. So in other words, since it's kind of hard to say exactly where you got COVID for anybody really at any level of science, where exactly did you contract it from whom? Difficult in most cases. What the Workers' Compensation Board did is to say, we're going to have a presumption that if you return to your workplace and get sick, that it happened there. So they didn't make people making workers' compensation COVID-related claims have to prove that they got sick or hurt, which is what we normally would say, on the job. Instead, they did a very reasonable thing and say, we're just going to presume it happened there, not make you prove that. And then that will trigger the benefits that you're entitled to. So it might very well be that we see the same thing in the civil context outside of workers' comp, where if somebody's saying, well, I'm going to sue this particular person for an injury that I sustained there, there might be a presumption that you got it there. So these are what you'll see. Now, of course, returning to the workplace, you do have this workers' compensation issue. If you get hurt or sick on the job, in most cases, you cannot sue your employer for that, but you're entitled to workers' compensation benefits. So you have that other level to think about there. But just from a practical standpoint, anybody being asked to come back to work in this climate, should be assured by their workplace that there are safety precautions in place that everyone's going to follow. Should ask what those protocols are so that they have them in writing. And if they're not there, should ask why before you go back to work. Very reasonable, very realistic, and very frequently happening now in this climate.